On last Friday, a three-judge panel of the United States Court of Appeals for the District of Columbia issued a decision that basically said the era of recess appointments is over. The three-judge court unanimously ruled that President Obama on January 4th, 2012 made 4 recess appointments which were unconstitutional. And therefore, said the court, these 4 individuals, one is already gone from the NLRB, so two NLRB individuals were in the case that was before this court, hold their seats unconstitutionally. The chairman of the National Labor Relations Board nevertheless said, in effect, the NLRB's open for business. I respectfully suggest a different sign should go up. Help wanted, nominations needed, and that the 2 NLRB members whose recess appointments were unconstitutional should leave the court because the decisions, leave the NLRB, because the decisions in which they participated, and there were 219 of them, cannot be valid if they're challenged, just as this one decision was vacated, cannot be challenged because since they were unconstitutionally there, the NLRB didn't have a quorum, and therefore, when those decisions are challenged under the ruling of this court, those decisions couldn't stand. They're important decisions. As the senator from Wyoming undoubtedly will mention more about, they involve such issues as micro unions. Now, several observers have said that the court's decision is broad. And in fact, Madam President, it's a breathtaking decision. It is a bold decision. But by all standards, it seems to be the correct decision. Here's why I say that. If you take an American history book in one hand and the United States Constitution in the other, and you read them both at the same time, you see that the Constitution, which was ratified a long time ago, before 1800, you see that the Constitution has in it Article 2, Section 2, which says that the President may make nominations of a number of people, such as Secretary of State Kerry, who was confirmed yesterday, of a number of people, but that those nominations require the advice and consent of the Senate. Now, we've done some work here in the Senate over the last 2 years, and we've improved the nomination process. We have eliminated a number of the nominations that are subject to advice and consent. And we have made it easier for people to move through, and we have expedited a large number of those provisions. For example, 273 of the 1,100 nominations that require advice and consent can be sent right to the desk by the President, and if a single senator doesn't want it to go through the entire process after the committee gets all the relevant information, the majority leader can just move after 10 days to confirm that person. But if it's a Secretary of State, or if it's a Secretary of Defense, or if it's a member of the National Labor Relations Board, the Senate has a constitutional responsibility to consider those nominees. I would suspect that the advise and consent role of the United States Senate is probably our best known power. This is the title of a book Alan Drury, I think, wrote in the late 1950s. Most Americans know about the advice and consent role of the Senate, and they know why we have it. We have it because our founders put their necks on the line in a revolution against the king, and they didn't want an imperial presidency. And so they put into place a system of checks and balances, which is being exercised this very moment because of the courts saying that the president's use of the check and balance. I ask for another 3 minutes, please. Court's use of the...
Is there objections? Without objection.
I believe we have 30 minutes for this discussion. Is that right, Madam President?
23 minutes remaining.
Yeah. Thank you. So as we look back over the history of checks and balances and the imperial presidency and the importance of making certain that we don't have an imperial presidency, we're reminded the reason we did that was a single word: liberty. Liberty. The revulsion by the founders who created this system and who then made sure that our president was a president, not a king. And George Washington, who exercised great modesty and restraint, impressed into the American character his own modesty and restraint when he asked that he be called Mr. President, not something more grand, when he retired to Mount Vernon after 2 terms, when he could have been President of the United States for life. So that's what the Constitution talked about. It said, for these important positions, the president may nominate, but if the Senate doesn't confirm them, they can't serve. Now, there's also a provision toward the end of Article 2, Section 2, about recess appointments. And here's what the court said when it got out its American history book and began to compare that with the Constitution. This was written for a time when it took Senator Houston of Texas. I asked Madam President that I have time to speak as if in morning business. Thank you.
Without objection.
So this was written at a time when Senator Sam Houston of Texas had to ride a horse, get on a steamboat, get in a stagecoach, and make his way to Washington over a period of 5, 6, or 7 weeks, and the same to go home. And when President Polk, when he had a vacancy in 1846 or 7 in the Attorney General's office, wrote a letter to someone in New Hampshire and invited him to take the position, and that took 2 or 3 weeks to get the letter, and then 2 or 3 weeks back came the answer, no. So communication was a little different back then, and so it was necessary for the government to operate, to put into the Constitution that when the Senate was home, which meant all over this big, grand country before days of communication and travel, that during a 4 or 5 or 6 month period, the president could appoint someone to that position during the recess, the Constitution says. The Constitution says, according to the court, that when a vacancy occurs during the recess, the president may make an appointment during the recess. So the court said they were talking about only one recess, and that's the one between the annual sessions of Congress, the one that ends when we get through in 2012 and that starts when we start in 2013. Now, since that time, starting right after the Civil War, the President and Congress have been inventing these various ideas about other recesses. We even got down to the idea where we created a recess for 3 days, a pro forma session, I should say, for 3 days, to prevent the President from making any, quote, recess appointment during that time. But what the court has said is that all that doesn't really matter, that the only recess during which a court may make a nomination is between the end of the annual session and the beginning of the next one. I believe the ruling is correct. I believe it'll be affirmed. I have no idea whether the Supreme Court will affirm it in whole, but surely they will at least say that the Senate itself, not the President, will decide when the Senate's in session and when the Senate's in recess. And if they do that, Madam President, the era of the recess appointment is over. There's no need for a recess appointment in a modern era where the Senate is in session almost all the time. And the recess appointment has become used by presidents to get around the checks and balances that are in Article 2, Section 2 of the Constitution that provide liberty for the citizens of this country by avoiding an imperial presidency. So I call on the NLRB to take down the open for business sign, put up one that says help wanted, nominations accepted. The NLRB can do a number of things, but the board cannot, as long as it doesn't have a quorum, and the 2 members who are there unconstitutionally should leave their positions immediately and accept no more pay. Madam President, the senator from Wyoming has been a leader on this issue, and I would like to now yield the floor and listen to his remarks.